The rain was coming down hard, drumming against the windshield of the patrol car as it crept along the highway. At 11:42 p.m., dispatch broke the silence. All units be advised. Possible homicide. Caller reports witnessing the incident. The voice on the 911 call was steady, measured, almost detached. The man didn't sound panicked. He didn't stumble over his words. He didn't ask what to do. Instead, he spoke as if he already knew his role. I saw him pull over. I saw what happened next. According to the call log, the witness described a man standing near a vehicle on the shoulder, hazard lights flashing, a brief confrontation, then violence. He gave specifics, details investigators would later say had not been released to the public, where the body fell, which direction the suspect fled, even how long the car idled before driving away. To detectives, this wasn't just helpful, it was decisive. Within hours, the statement was formalized. Within days, it was referenced in an affidavit. Within weeks, it became the cornerstone of the case. Investigators wrote that the witness corroborated the timeline and confirmed suspect presence at the scene. The system moved quickly after that. A person of interest became a suspect. A suspect became a defendant. And eventually, a jury was told that someone had seen everything. But years later, when the case was quietly reopened for review, a simple task produced an impossible result. No DMV record, no social security number, no address, no photo. The name appeared only in police paperwork. The witness who helped solve the case had left behind no proof that he had ever lived at all. And that's when investigators were forced to confront a question the justice system is never comfortable asking. How do you cross-examine someone who was never real? The body was discovered just after midnight, less than a mile from the county line. A local delivery driver noticed something dark near the shoulder of the road and pulled over, assuming it was debris from an accident. When his headlights caught the shape of a human arm, he froze. He would later tell police that for a few seconds, his brain refused to accept what he was seeing. The victim was a 34-year-old man with no significant criminal history. Married, recently promoted. According to phone records, he had left work late and was heading straight home. He never made it. The crime scene told a restrained but deliberate story. No signs of a struggle, no scattered belongings. The victim's wallet was still in his pocket. This wasn't a robbery gone wrong. This was personal or planned. The medical examiner would later rule the death a homicide. The cause, blunt force trauma to the head, precise, controlled. Not the kind of injury caused by panic or rage, but by intent. Detectives quickly realized what wasn't there mattered as much as what was. No weapon recovered. No surveillance cameras covering that stretch of road. No eyewitnesses stepping forward on their own. In cases like this, investigators usually rely on forensics to speak when people won't. But the rain had worked against them. Tire impressions were washed out. Any footprints that might have told a story were gone. By sunrise, the pressure was already building. A man was dead. The location suggested he was lured or intercepted, and someone somewhere had walked away without leaving their name behind. At least that's what it looked like, until a witness appeared. The suspect's name surfaced less than 48 hours after the body was found. On paper, he made sense. He lived within driving distance of the crime scene. He had crossed paths with the victim before. And most importantly, he didn't have a solid alibi for the exact window of time when the murder occurred. Detectives brought him in just to talk. From the moment he sat down in the interrogation room, his behavior stood out, not because he was erratic, but because he was controlled. Too controlled. His posture was upright, hands folded neatly in front of him. His voice stayed even, never rising, never cracking. When asked about the night of the murder, he answered quickly, almost mechanically, as if the story had been rehearsed. Psychologically, this presented a problem. Guilty suspects often over-explain. Innocent ones tend to ramble. He did neither. Instead, he gave short, precise answers and waited. No nervous filler, no emotional appeals, just silence. When detectives pressed him about his relationship with the victim, his expression barely changed. There was no visible anger, no grief, no fear, just detachment. To investigators, that emotional flatline raised alarms. They noted it in their reports as unusual affect. But unusual doesn't mean illegal, and at that point they still had no physical evidence tying him to the crime. No DNA, no weapon, no witnesses. Without corroboration, the case risked stalling. And then detectives received word that someone had come forward, someone who claimed to have seen the suspect that night, standing near the road, near the victim. At the exact moment everything went wrong. Suddenly, the suspect's calm demeanor looked less like composure and more like calculation. And for investigators desperate for certainty, that was enough. The witness didn't arrive with sirens or flashing lights. He walked into the station quietly, as if he already knew where to go. According to the intake log, he said he had waited before coming forward because he didn't want to get involved. A familiar phrase. One detectives hear often and usually accept without question. He claimed he was driving home that night when he noticed a vehicle pulled over on the shoulder, hazard lights blinking, a man standing nearby, pacing. Then he recognized the face, the suspect. What made the statement immediately valuable wasn't just the identification, it was the detail. The witness described the sequence of events in a clean, linear way. No hesitation, no contradictions, no uncertainty. He placed the suspect at the scene during the exact time window of the murder. He described the victim's position with precision. He even noted how long the car remained stopped before driving away. Detectives would later say these were details only someone present could have known. The witness signed a formal statement. An affidavit was prepared. The narrative investigators had been struggling to solidify suddenly locked into place. From that moment on, the investigation shifted. The suspect was no longer one of several possibilities. He was the suspect. There was no lineup, no recorded photo identification. The witness claimed he already knew who he saw. That certainty was treated as strength, not something to be tested. In their reports, detectives wrote that the witness was credible, coherent, and cooperative. No one asked why he had no verifiable connection to the area. No one questioned why no one else had seen him. At the time, there was no reason to. The case finally had what every prosecution needs, someone willing to say, "I was there." And once that sentence entered the record, everything else became easier to believe. The second interview felt different from the moment it began. The suspect noticed it too. Detectives no longer asked open-ended questions. Their tone was firmer. Their posture leaned forward. The atmosphere in the room shifted from curiosity to accusation. They didn't start with evidence. They started with certainty. "Someone saw you there." The suspect paused, just briefly. His eyes dropped to the table, then back up. It was the first visible crack in his composure. Psychologically, that reaction mattered. When innocent suspects are confronted with supposed eyewitnesses, they often display confusion or disbelief. Guilty suspects tend to go quiet, calculating their next move. He did the latter. His answers shortened. His breathing slowed. He stopped volunteering information altogether. Detectives leaned on the witness statement hard. They referenced it repeatedly, framing it as an unmovable fact rather than a claim. This is a common interrogation tactic. Present an allegation as settled truth and watch how the suspect adapts. At one point, the suspect asked, "Who is saying this?" The detectives deflected. Names weren't important, they said. The evidence was. That uncertainty worked against him. His body language changed. Arms crossed, shoulders tightening. The confidence he'd shown in the first interview faded into guarded silence. After 2 hours, he asked about a lawyer. The questioning stopped. But by then, detectives felt they had what they needed. No confession, but no clean denial either. And in their minds, the witness had already done the most important work. He had rewritten the suspect's calm as guilt. By the time the case reached the courtroom, the narrative was already set. The prosecution didn't frame it as a mystery. They framed it as a reconstruction. According to the DA, the timeline was clear. The motive was implied. And most importantly, the suspect had been placed at the scene by an eyewitness, a neutral third party with nothing to gain. In court, the witness wasn't presented as dramatic or emotional. He was described as reliable, observant, calm, someone who simply happened to be in the wrong place at the right time. Jurors tend to trust that kind of person. The defense tried to push back. They highlighted the lack of physical evidence. No weapon, no DNA, no surveillance footage. They argued that the case relied too heavily on a single account, but the witness's statement anchored everything. Whenever doubts surfaced, the prosecution returned to the same point. Someone saw him. The jury never saw inconsistencies. They never saw uncertainty. What they were shown was a clean version of events, supported by police reports, affidavits, and the quiet authority of the state. The witness was referenced repeatedly, even when not physically present in the room. His words carried weight far beyond their length. After deliberation, the verdict came back guilty. The judge handed down a lengthy sentence. The courtroom emptied. The public moved on. Another case closed. At the time, no one questioned the foundation it was built on. Because in the justice system, once a story feels complete, few people are motivated to reopen it. And the witness, the man who had seen everything, faded quietly into the background. Or so everyone thought. The case resurfaced quietly. No media pressure, no public outrage, just a routine review triggered by updated standards and a growing backlog of convictions built on thin evidence. A cold case analyst was assigned to audit the file from the beginning, timelines, reports, interviews. The goal wasn't to challenge the verdict, only to verify it. At first, nothing seemed unusual. The crime scene photos matched the reports. The medical examiner's conclusions were consistent. The suspect's interviews showed no obvious coercion. Then the analyst reached the witness. Standard procedure required confirming contact information, even years later, a formality, usually a quick database check. Except this time, the search came back empty. No DMV record under the witness's name. No social security number. No address history linked to the file. At first, it looked like a clerical issue, maybe a typo, maybe an alias. So the analyst widened the search. Still nothing. The name appeared nowhere outside the case file itself. Not in court databases. Not in employment records. Not even in archived utility listings. It was as if the witness had materialized for one statement and then evaporated. The analyst flagged the anomaly and escalated it. Supervisors assumed the same thing, paperwork error, a missing attachment, something mundane. But when they pulled the original affidavit, a new problem emerged. The witness's signature didn't match any known records, and the contact information listed led nowhere. The question was no longer administrative. It was existential, because the case hadn't just used this witness. It had depended on him. And now the system was being asked to confront an unsettling possibility. What if the person who held the case together had never existed at all? Once the possibility was raised, it couldn't be put back. Investigators began pulling every reference to the witness from the case file. Reports, notes, supplemental narratives. His name appeared again and again, but always secondhand. Quoted, summarized, never independently verified. There were no photographs of him entering the station, no recorded interview, no video of a lineup, just words on paper. When analysts traced the affidavit, they found it had been typed, not handwritten. The signature was scanned. No original copy existed in evidence storage. That alone wasn't proof of wrongdoing, but it was unusual for a case this serious. Next, they looked for corroboration. Did any officer independently confirm speaking to the witness? Did any report place him physically at the scene? The answers were vague. Most references used the same phrasing, the same descriptions. It was as if the language had been copied and pasted across reports, reinforcing itself without adding anything new. Psychologically, This raised a disturbing possibility. Once investigators believe a narrative is true, confirmation bias can turn assumptions into facts. Details stop being questioned. Gaps get filled automatically. The witness had become real because everyone treated him as real. When supervisors contacted the original detectives, the responses were defensive. No one remembered meeting the witness directly. No one could describe him beyond what was already written down. And yet, no one denied he existed. That contradiction was the most alarming part, because it suggested something worse than a missing person. It suggested a story that had been collectively accepted without ever being tested. A witness constructed not out of malice, but out of momentum. And now, years later, the system was staring at the result. A conviction resting on someone who may never have stood in that room at all. With no proof the witness existed, investigators were left with theories, none of them reassuring. The first possibility was simple error, a real person poorly documented, a name misspelled, records lost over time. But that explanation collapsed quickly. Even the most transient individuals leave something behind. A citation, a paycheck, a digital footprint. Here, there was nothing. The second theory was more troubling, that the witness was never a single person, but a composite. Fragments of tips, rumors, and assumptions merged into one authoritative voice. In psychology, this is how narratives solidify. Repetition creates confidence, and confidence replaces verification. Once written into an affidavit, the witness became untouchable. A third theory lingered at the edge of the conversation, rarely spoken aloud. That the witness was fabricated, not necessarily out of malice, not as part of a conspiracy, but as a shortcut, a way to close a case that felt obvious to the people working it. Tunnel vision plays a powerful role in investigations. When detectives believe they've identified the right suspect, contradictory evidence feels like noise. Supporting details, even weak ones, feel like confirmation. No one officer had to invent the witness outright. All it took was for no one to challenge him. By the time the case reached court, the witness was no longer a person. He was a function, a tool that made uncertainty disappear. And once the system moved forward, it couldn't admit what it had done without questioning everything else that depended on it, including the verdict. The review did not end with a dramatic revelation. There was no confession, no document proving fabrication, no single moment where the truth became undeniable. Instead, there was absence. The witness could not be located because there was nothing to locate. Legally, that wasn't enough. The court ruled that while the missing witness raised serious concerns, it did not conclusively prove misconduct. The conviction stood. Appeals were denied. The system chose stability over uncertainty. The defendant remains incarcerated. The detectives involved retired or moved on. No disciplinary action was taken. The case file was quietly reclassified, flagged but unresolved. In the end, no one could be held accountable for the witness, because accountability requires a person, and the witness had never been one. Psychologically, this case exposes something uncomfortable about the justice system. It does not collapse when evidence is weak. It collapses only when doubt becomes undeniable. Here, doubt was visible but never absolute, and so the verdict survived. Today, the witness exists in only one place: in typed statements, in sworn affidavits, in the collective agreement that no one questioned at the time. A man went to prison because someone said, "I was there." And years later, the system discovered it had no idea who had said it, or if anyone ever had, because the most dangerous witness is the one who never existed.